Hello viewers, in this lesson we will learn about public issue and private placement of shares as securities. Objectives: to learn about the public offer of shares as securities, to learn about the private placement of shares as securities. This lesson explains the various issues relating to the public offer and private placement of shares as securities. Public offer. The share capital of a company, whether equity or preference capital, can be procured by public offer and private placement as provided under Section 23 of the Companies Act 2013. Public offer can be given only by public companies, as private companies cannot go for public offer of share capital. A public company can issue shares to public through prospectus by complying with the provisions under Sections 23 to 41 of the Companies Act 2013. A public company can also procure share capital by rights issue as provided under Section 62 of the Companies Act 2013. Further, it can also issue bonus shares under Section 63 of the Companies Act 2013. A public company can also procure share capital by way of private placement as provided under Section 42 of the Companies Act 2013. Under Section 52, the shares can be issued at a premium, and under Section 53, read with Section 54, the shares can be issued at a discount. Section 54 contains provisions on issue of sweat equity shares also. A company can also issue preference shares in accordance with the provisions of Section 55. A private company may issue securities by way of rights issue as provided under Section 62 of the Companies Act 2013 or bonus issue as provided under Section 63 of the Companies Act 2013. Further, it can also issue shares by way of private placement as provided under Section 42 of the Companies Act 2013. Sections 24 to 42 of the Companies Act 2013 and the relevant rules thereof contain detailed provisions as to the method and procedure to issue the share capital either through the public issue by public companies or through private placement by both the public and private companies. The details are discussed in this lesson. Contents of prospectus. Section 26 of the Companies Act 2013 contains the contents of a prospectus. The contents include various details about the directors, management, various reports like the auditor's reports, the risk factors of the project, the agreement entered into, and other details as prescribed under Section 26. The students are advised to thoroughly study the provisions under Sections 23 to 42 of the Companies Act 2013 pertaining to the public offer and private placement of securities, and also the SEBI issue of capital and disclosure requirements regulations 2009 and SEBI listing obligations and disclosure requirements regulations 2015. They must also further study the SEBI public offer and listing of securitized debt instruments regulations 2008, securities contracts regulation, stock exchanges and clearing corporations regulations 2012, and companies prospectus and allotment of securities rules 2014 and other related rules, regulations and guidelines issued by the SEBI and also MCA. Misstatement of information in prospectus and the rule of golden legacy. The Companies Act calls for furnishing full, frank, and honest disclosure of all material facts with scrupulous accuracy in the prospectus by the concerned persons. This rule is called Golden Rule, which was laid down in New Brunswick and Canada Railway and Land Company versus Muggeridge by the House of Lords, reported in 1863, LT 651, Chancery. Subsequently, this rule was described as golden legacy by Justice Pagewood in Henderson versus Lacon, reported in 1867, Chancery. Any misstatement made intentionally in the prospectus entails civil and criminal liability on the persons responsible for making the misstatement. Section 37 provides remedies against any misstatement which are narrated hereunder. Civil liability. Under Section 35 of the Companies Act 2013, every person who happened to be a director, promoter, or an expert referred to in subsection 5 of Section 26 of the Companies Act at the time of issuing the prospectus and responsible for making the misstatement is liable for payment of compensation to the affected persons. However, the charged persons can take the defense that they have not given consent to be the directors, or that they withdrew the consent before the issue of prospectus, or that the prospectus was issued without his consent or knowledge and they issued a reasonable public notice. But if it is proved that the persons concerned issued the prospectus with an intent to defraud the applicants for the securities, they are personally responsible to the affected persons without any limitation of liability for all or any of the losses or damages. In Derry versus Peake, reported in 1889-14, AC 337, the House of Lords held that the directors, if honestly believe that the statement given by them in the prospectus is to be true based on a reasonable ground, they are not liable for the misstatement. Criminal liability. Section 34 of the Companies Act 2013 contains the provisions on criminal liability, and the concerned persons are liable as provided under Section 447. Under this Section 447, the concerned person shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. However, where public interest is involved, the term of imprisonment shall not be less than 3 years. The defenses stated afore against civil liability are available against criminal liability also. Other provisions relating to public issue of securities. Under the provisions of the Companies Act 2013, the details about the deemed prospectus are dealt with. Under Section 27 of the Companies Act 2013, a company shall not at any time vary the terms of a contract referred to in the prospectus except by confirmation by the company obtained in general meeting following the procedure under law. Section 28 deals with offer of sale of shares by certain members of a company. Section 29 deals with public offer of securities to be in demat form. Section 30 pertains to advertisement of prospectus. Section 31 relates to shelf prospectus, and Section 32 relates to red herring prospectus. Section 33 pertains to issue of application forms for securities. Section 36 contains the provisions on punishment for fraudulently inducing persons to invest money. Section 38 deals with punishment for personation for acquisition, etc. of securities. Section 39 deals with allotment of securities by a company wherein procurement of minimum subscription is mandatory. Irregular allotment is basically voidable. Section 40 pertains to securities to be dealt with in stock exchanges, and Section 41 deals with issuing global depository receipts. Viewers, now we will learn about the private placement of shares as securities. Section 42 of the Companies Act 2013 contains the provisions related to offer or invitation for subscription of securities on private placement. Thus, a public company also can procure share capital from subscribers on private placement, subject to fulfillment of the conditions under Section 42. The provisions are as follows. Without prejudice to the provisions of Section 26, a company may, subject to the provisions of this section, make private placement through issue of a private placement offer letter. Subject to subsection 1, the offer of securities or invitation to subscribe securities shall be made to such number of persons not exceeding 200 or such higher number as may be prescribed, excluding qualified institutional buyers and employees of the company, being offered securities under a scheme of employees, stock option as per provisions of Clause B of subsection 1 of Section 62 in a financial year and on such conditions, including the form and manner of private placement as may be prescribed. Explanation 1. If a company, listed or unlisted, makes an offer to allot or invite subscription, or allots or enters into an agreement to allot securities to more than the prescribed number of persons, whether the payment for the securities has been received or not, or whether the company intends to list its securities or not on any recognized stock exchange in or outside India, the same shall be deemed to be an offer to the public and shall accordingly be governed by the provisions of Part 1 of Chapter 3. Explanation 2. For the purposes of this section, the expression qualified institutional buyer means the qualified institutional buyer as defined in the Securities and Exchange Board of India, Issue of Capital and Disclosure Requirements, Regulations 2009 as amended from time to time. Private placement means any offer of securities or invitation to subscribe securities to a select group of persons by a company other than by way of public offer through issue of a private placement offer letter and which satisfies the conditions specified in this section. No fresh offer or invitation under this section shall be made unless the allotments with respect to any offer or invitation made earlier have been completed or that offer or invitation has been withdrawn, abandoned by the company. Any offer or invitation not in compliance with the provisions of this section shall be treated as a public offer, and all provisions of this Act and the Securities Contracts Regulation Act 1956 and the Securities and Exchange Board of India Act 1992 shall be required to be complied with. All monies payable towards subscription of securities under this section shall be paid through check or demand draft or other banking channels, but not by cash. A company making an offer or invitation under this section shall allot its securities within 60 days from the date of receipt of the application money for such securities, and if the company is not able to allot the securities within that period, it shall repay the application money to the subscribers within 15 days from the date of completion of 60 days. And if the company fails to repay the application money within the aforesaid period, it shall be liable to repay that money with interest at the rate of 12% per annum from the expiry of the 60th day. Provided that monies received on application under this section shall be kept in a separate bank account in a scheduled bank and shall not be utilized for any purpose other than A, for adjustment against allotment of securities, or B, for the repayment of monies where the company is unable to allot securities. All offers covered under this section shall be made only to such persons whose names are recorded by the company prior to the invitation to subscribe, and that such persons shall receive the offer by name, and that a complete record of such offers shall be kept by the company in such manner as may be prescribed, and complete information about such offer shall be filed with the registrar within a period of 30 days of circulation of relevant private placement offer letter. No company offering securities under this section shall release any public advertisements or utilize any media, marketing or distribution channels or agents to inform the public at large about such an offer. Whenever a company makes any allotment of securities under this section, it shall file with the registrar a written of allotment in such manner as may be prescribed, including the complete list of all security holders with their full names, addresses, number of securities allotted, and such other relevant information as may be prescribed. If a company makes an offer or accepts monies in contravention of this section, the company, its promoters and directors shall be liable for a penalty which may extend to the amount involved in the offer or invitation, or 2 crore rupees, whichever is higher, and the company shall also refund all monies to subscribers within a period of 30 days of the order imposing the penalty. For exceptions, modifications, adaptations, the students are advised to refer to the circulars, orders of MCA. Well, viewers, I hope you have enjoyed this lesson. We will meet again. Thank you.